Hey y'all, Rob here with atx.legal, and today I'm going to talk about how much do PI lawyers cost. So you've no doubt seen the commercials that say no cost until we recover or unless we recover, and you may be wondering how that works. You might already know, and for those people who already know how contingency fees work, this video is not for you. Go ahead and click to another video. But if you don't know, if you're curious how it works, stick around. A contingency fee is a percentage of the total recovery that you get at the end of the case. That's it, that's the whole thing. But there are some intricacies to it that you should know about before you hire an attorney. A typical contingency fee for a PI attorney is between 33% and 40%. I will typically charge that 40% if we do have to file a petition, and it's less if we don't get to that stage and we can come up with an agreement before filing. In the state of Texas, these contingency fees need to be in writing, so you will have a written contract with any personal injury attorney that's charging you a contingency fee. Now, a key factor about the contingency fee is that it's taken on the entire settlement. So let's say, for example, you get a full settlement of $100,000. If the contingency fee was 35%, that's a $35,000 fee to your attorney. Now, that doesn't take into account medicals and other costs. So before you get your settlement, you still have to take out whatever medical fees there are, and any court costs such as filing fees, expert fees, or whatever else was paid in service of the lawsuit. Now, if you don't recover anything, so let's say you take it to trial and unfortunately you lose the case, it's the attorney who would end up covering costs of the case, but you would still be on the hook for the medical bills. But one upside is any money that you do receive as part of the settlement is usually tax-free. Now, that contingency fee can seem like a lot, and in a lot of circumstances it really is, but you have to keep in mind a number of factors. First of all, the attorney is taking on a risk when he takes on any case. If the facts aren't as you're saying they are, if there is some other factor such as a defendant that has the inability to pay, the attorney's taking the risk that he's going to get to the end of this trial with all the costs and time spent on the trial, and he's going to have nothing to show for it. So that is taken into account when attorneys are setting their contingency fees. And also consider that in many cases, an attorney is going to be able to get you an additional recovery far in excess of what that contingency fee is versus what you would have gotten without an attorney. Or in many cases can even flip it from an insurance company who's unwilling to pay and get a settlement out of that and flip that liability so that you do get recovery, whereas without an attorney, you wouldn't have gotten any recovery at all. None of this has been legal advice, but if you do want legal advice, if you've had an accident, you can visit us at atx.legal for a no-cost consultation.